All right, shout out to my boy here. Thank you for sending me this new stuff here. Let me share my screen. Okay, let me move this over so we can take a look at this. This is called Tender of Payment under UCC Section 3, 604, A Forgotten Defense. Jeffrey M. Goldsmith, Ohio State Law Journal, Volume 39, number 4, 1978, 833-854. Downloaded from the Knowledge Bank. Oh, some knowledge, huh? Tender of payment under UCC Section 3-604, a forgotten defense. A tender of payment may be defined as an unconditional offer by a debtor or obligor to pay another in current coin of the realm. Where have we heard that before? Brian, did you see that? Coin of the realm. A sum not less in amount than that due on a specific debt or obligation. Let me read that again. A tender of payment may be defined as an unconditional offer by a debtor or obligor to pay another in current coin of the realm, a sum not less in amount than that due on a specified debt or obligation, end quote. Tender of payment typically arises within the law of commercial paper when a party obligated on a negotiable instrument at its maturity date tenders the sum due to the holder. If tender is refused, and the holder subsequently brings suit to collect on the obligation, the party obligated may assert the prior tender as a defense to liability for interest, costs, and attorney fees accruing on the instrument after the effective date of the tender. Article 3 of the Uniform Commercial Code has codified a tender of payment rule for commercial paper in Section 3-604. Number 1, any party making tender of full payment to a holder when or after it is due is discharged to the extent of all subsequent liability for interest, costs, and attorney fees. 2, the holder's refusal of such tender wholly discharges any party who has a right of recourse against the party making the tender. 3, where the maker or acceptor of an instrument payable otherwise than on demand is able and ready to pay at every place of payment specified in the instrument when it is due, it is equivalent to tender. Tender of payment under Section 3-604 has been litigated only infrequently since the enactment of the code. Several reasons may be postulated for this lack of legal attention to tender. First, it may be that tender of payment infrequently arises in modern commercial transactions. As will be seen, tender only becomes an issue when the holder delays collection of the instrument after it matures and the party obligated on the instrument desires to stop the running of interest and costs on the obligation. It is possible that modern holders promptly collect their debts and hence tender of payment does not arise as an issue. In the early days of the common law, when the doctrine of tender of payment arose, great distances and gaps in communication could easily cause delay in the collection of negotiable instruments. The modern commercial world does not operate under similar disabilities. Second, it is possible that parties obligated on negotiable instruments are unaware that tender of payment exists as a mechanism to stop interest and costs from running on an instrument after its maturity date. Tender of payment in the negotiable, it's 1:30 in the morning, in the negotiable instruments setting has been ignored in legal literature. There's a 5 up there. J. White R. Sumner's Handbook of the Law under the Uniform Commercial Code, 13 to 18, that's subsection, at 443, 1972, makes only a passing reference to tender of payment under subsection 3-6044A, general discussion of the law of tender. See comment, the law of tender in Texas, 29 Baylor L. Review, 325, 1971. Section 3604 has not been the subject of commentary since the enactment of the code. Third, because Section 3-604 of the code fails to define tender, the definition must be derived from the common law. And here's the 6 down here. It says UCC 1-103 reads, unless displaced by the particular provisions of this act, the principles of law and equity, including the law merchant and the law relative to capacity to contract. There's that word, capacity to contract. Principal and agent estoppel, I'm reading down here on these references, estoppel, fraud, misrepresentation, duress, coercion, mistake, bankruptcy, or other validating or invalidating cause shall supplement its provisions. Boy, oh boy, that's like a lot of legalese, but I'm trying to understand all this stuff. I'm going to read that again. Down here on the bottom, look where it says 6. UCC 1-103 reads, unless displaced by the particular provisions of this act, the principles of law and equity, including the law merchant and the law relative to capacity to contract. You know, capacity means Brian Parker, he was bringing that up, capacity. I was like, capacity, does that mean like a container? You fill it up, and if the capacity is full, he says, okay, that's one definition. Another one was like mental capacity, that you have the mental capacity to do this or that, because that's another one. But he was talking about capacity of office, to be able to have authority to stand or to have the role, or like, you know, the CFO, CEO, stuff like that. Isn't that what you said, Brian? The capacity to contract. And I remember seeing something in that equity jurisprudence that it was saying something about married women. And I was thinking about that, how they were saying, you know, if you're an infant or a married woman or an idiot, that you don't have the capacity to contract. And I was thinking about that. I'm going, I guess if you're a married woman, you know, and the husband's supposedly the head of the wife, in a way, it's kind of like coercion, or you're kind of like joined, you know. So if he says, yeah, I want to buy this timeshare, and you're like married to the person, it's kind of like, yeah, because he wants to do that and he's the husband or the head or whatever, you go ahead and do it. I was trying to think of that. Like, why would the lady or the woman that's married not have the capacity to get into contracts. And I was thinking, in a way, she's following the leader, the family. And so I was like, oh, that could be a good thing. If you want to get out of something, you could say, hey, I was a married woman at that time. I was not in the capacity to contract. So that could be a really good way. Another word down here I saw was mistake or coercion or duress. But misrepresentation, now that to me is when they do that novation thing that Lori was talking about, Lori L. She talked about this thing called a novation where they, you have your name the way it's spelled properly, and then they convert it, change it to the all caps name. Is that what you meant, Lori? I hope so. But misrepresentation, that thing is now an entity. That's not you, the living person or the living woman or man. It's now an entity. It's a contrived, constructed thing instead of you as the living soul. So it gets converted into a novation, as far as I'm understanding that L'Oreal was talking about. That thing is the one that has the deed's name in it, but then they have other parties that are the beneficiary as well. And then they stick us with the liability because you're thinking that your name, all caps, that's you, that's not you. But you're like, okay, that's my debt. Yeah, I paid for that car. I paid for that timeshare. I paid for that house, whatever. And the deed has your name in it. It's all caps. But somebody else's, you just have the usufruct. You get the usage of that and you got to pay all the taxes and everything. Yeah, you get the enjoyment of it, but you don't really own it. Somebody else owns your name because they are doing business as your name. So whether it's the county, yeah, it's the county, I think. It's an interesting thing. But down here, go back to this. Capacity to contract, principal and agent. Estoppel. We can look up these words too, by the way, so you know what these words mean. This is important. Fraud. Yeah. Misrepresentation. You're the owner. Am I? Does that mean it's my private property? No. Well, wait a minute. I thought you said I'm the owner, but it says tenant on this deed. That means you're a renter. Your deed says tenant, joint tenant on your house. Go look at your deed. If it says tenant, you're not the owner. That is misrepresentation right there. Boom. So let's see, duress, when they're forcing you, like, you better sign this ticket or we're going to take your car away and your dog and you too, Toto. Okay, coercion. Yeah, that's coercion too. You better do that or else we're going to do these things to you. You better get that shot or else you're not going to be able to buy or sell. Yeah, but it's an experiment. It's not really a vaccine because, a vaccine in your book would be immunization. But if vaccination is not immunization, then it's not really a vaccine, right? So I'm just saying. It's an experiment. And I'm not going to consent to be in a guinea pig. Just saying. That's coercion. That was my example. Mistake. Oh, I made a mistake in saying the word V. Didn't mean to say that. Made a mistake. Okay, then there's bankruptcy or other validating or invalidating cause shall supplement its provisions. All right, so 6, where was I? Up here on the top, second paragraph right here. Parties obligated on negotiable instruments may be unwilling to follow the rituals associated with tender at common law. Could that be like, I don't really want to sign my name on this deal out of ignorance or desire to avoid the bother of making a tender. The purpose of this comment is to explore the law of tender, of payment, in the negotiable instruments setting through an examination of tender under the common law, the negotiable instruments law, and section 3-604 of the code, and to explain the lack of use of section 3-604. Apparently, regular people don't know about all this kind of stuff. They don't know about the codes. They don't know about the laws. They're just like, sign here, sign here, sign here. Okay, you're the new happy owner of a new car. Drive it off the lot and lose all of your, basically lose all of the equity or whatever when you drive it off the lot. Because yeah, basically just paid for it just now and you didn't know it, but they're not going to tell you that. Exploration of the nature of tender of payment as it evolved from the common law to its present day form will reveal that many problems related to tender of payment remain unresolved by the code. This comment will propose solutions to those problems. Yay, we want solutions. Number one, or I, tender of payment under pre-code law. Tender of payment arises in a great variety of contractual settings. For example, a mortgager may tender a payment due on a mortgage to the bank. An insured may tender a premium due on a policy to an insurance agent. Or a consumer may tender money due on an automobile to a loan company. You know, they're using really big words here, but they're basically talking about, the example is when you have a mortgage or a house loan, that you may write a check or tender payment due on a mortgage to the bank. Or like you have insurance. Hey, what happened? Go back. Go back. Oh, where are we? Oh, right here. Here's the other example again. Like you have insurance for, you know, your car or whatever. Then you're going to tender the premium due on a policy to the insurance agent. Or a consumer, you're going to go buy something. You may tender money, get some monopoly money, get your Federal Reserve notes due on an automobile to a loan company or to the bank. Those are the three examples that they use there. In order to clarify how tender of payment works for commercial paper, it is helpful to illustrate how and why tender of payment may arise in this context. A, the negotiable instrument setting. Two hypothetical negotiable instruments reveal typical contexts in which tender payment may become an issue. Let's go to this 8 though, down here. These on the very bottom of the page, you see that little reference 8. These are not the only commercial paper contexts in which tender payment may be an issue. Similar considerations prevail when a party acts as an acceptor of an instrument, that is, agrees to honor the instrument as presented. See UCC 3-410. This comment will not examine the problems associated with the tender of a check in satisfaction of a debt. They're just letting you know. That's their disclaimer. See comment, accord and satisfaction under the UCC 1-207, 38, Ohio State. LJ 9/21/1977. All right, so we're going to go back up to where we saw the little 8. Where did I see the little 8 at? 6, 7. Where did I see 8? Oh, right here, right here. Boink, right there. Last sentence right here. In the first, A, in exchange for $1,000 loan from B, states, I promise to pay B, Bank of America or whoever, or order. Or let's say, I promise to pay Verizon for my phone bill. You know how they try to get you to promise to pay? Excuse me. Could these things be more annoyingly loud? Why do they make paper like this? I know, because they don't want this thing to stick, right? Oh, I'm taking the blue pill. I need my voice lubricated. It's like 1:30 in the morning here. All right. Excuse me for the noise. I promise to pay Verizon or order the principal sum of, 1,000 plus 10%. No, okay, that's a bad example. I don't mean Verizon. You're going to pay somebody for their loan, whatever, principal sum of $1,000 plus 10%. That's a lot. Interest compounded annually. Principal and interest due. Darn it. I hate it when that happens. Okay. Of the date of this instrument. From the date of this instrument. The second instrument is a variation on the first and reads, I promise to pay B or order. I order a payment, the principal sum of 1,000 plus 10% interest compounded annually. Principal and interest due and payable at the First National Bank of New York. 1 year from the date of this instrument. In both cases, A is the maker of the note. That would be, I promise me is the maker of the note, and B is the payee to the First National Bank of New York. As long as B retains a right of payment on the note. Ooh, so this is how they do it. They get you on the phone. You want your phone service? You want to give a promissory note or promise to pay? Then they retain the right of the payment on that note. Oh, it's September or something. You didn't pay your bill on the 16th, so we're going to shut off your service. So that's what they're doing right there. So they are termed the holder because you made a promise to pay. I hate it when they hold you like that. Like they got you by the balls. It's like, I already tendered you payment for the phone bill, but we didn't get it. You just need to apply it, like adjust the ledger, balance out the books, zero the account. Now, we didn't get any payment. Really? I have a copy here of the actual money order that I sent you and the green card that shows the signature that the CFO actually received it. Well, I think that the executives already sent you a letter and they consider that closed, that account or that case closed. So reopen that case because it's not closed, okay? I did already tender you payment and you promised to pay by next week or we're going to turn off your phone. Well, technically, I already paid. I'm not planning on paying the whatever it is that you think I owe. So that's where I'm at right now. I'm just saying. That was my little example. I'm trying to put this boring language here into something that I can use. So as long as B, Verizon, or whoever, they retain a right of payment on the note, he is termed the holder. The difference between the two notes is that the second instrument is domiciled, that is, payable at a place specified in the instrument. Oh, okay. I think that First National Bank of New York, that would be like Verizon Wireless right there. That's the domicile. Okay, so notes may be domiciled anywhere, but the most common domicile is a bank. The first note up here, the example up here on the top, I promise to pay B, blah, blah, blah. So the first note is payable on demand anywhere. Interesting. In either case, B has the right, the bank or Verizon, they have the right to collect $1,000 plus 10% interest 1 year from the date of the note. The problem is that B, the holder, is not required to present the note for payment to A, the maker, on the date of the note's maturity. Okay. A's obligation to pay the principal and interest continues whether B collects on the date provided for in the note or 10 years later. Early English law established that makers of notes payable on demand had no right to presentment of the note for payment at its maturity. Oh, that's interesting. I'll read that part again. Listen to this. Pay attention. Like Eon says, pay attention. Early English law established that makers of notes, like you would be a maker of the note, payable on demand, like you have to give it to them right now, that you had no right to presentment of the note for payment at its maturity. So like when it's due, like in a month or a year. This rule, this was early English law, this rule was in contrast to the law of checks, which required prompt presentment by the holder for payment. I'm going to assume that checks means like a bank check. That's what I'm going to assume that this means, the law of checks. They could mean the law of checks and balances. I don't know. What do they mean by law of checks? But let's just keep reading. The English courts, however, did adopt the check rule for instruments domiciled at a bank. Since notes domiciled at a bank were analogous to an order on the bank to pay the note, I order you to pay this note. The English courts took the view that presentment should be necessary. So maybe that's why we have checks, like a checking account check. Is that what that means? Get the check. Here you go. I'm ordering you to pay. Pay the person this who hands you this. Maybe that's what they're saying here. That's what I'm thinking. All right, so since notes domiciled at a bank were analogous to an order on the bank to pay the note, the English courts took the view that presentment should be necessary. Now let's go down to 11, down here at the bottom. Oh, I skipped on some other ones too. Let me read 9, 10, and 11. 9, see here on the bottom of the page down here? C. Rowe versus Young, 2 Broad and Bing 165, CP 1820. Stefan, instruments payable at a bank. And then 10, failure to present a check promptly for payment absolve the drawer from liability for any loss occasioned by the delay. Oh, okay. So like, you know how you write a check and you got to pay for your rent or something? Failure to present a check promptly for payment means that you're late. You didn't give them to them, you didn't give them the check on the 1st of the month. You gave it to them on the 18th. So it says it's absolving the drawer, that person, like your landlord or whoever, it's absolving the drawer from liability for any loss occasioned by the delay. And 11 says, see Sanderson versus Bose, 14 East 500, CP 1811. Stefan Super Note 9 at 61-62. The result is still good in good law in England. Business and banking. All right, so we'll go up to, oh yeah, because here's 9, there's 10, and here's 11. So this distinction between domiciled and non-domiciled instruments did not survive in the United States. In 1839, case of Wallace versus McConnell, the United States Supreme Court refused to require presentment for payment of domiciled paper. When the suit is against the maker of a promissory note, payable at a specified time and place, no demand is necessary to be averred upon the principle that the money to be paid is a debt from the defendant that is due generally and universally and will continue due, though there be a neglect on the part of the creditor to attend at the time and place to receive or demand it. This is so legalese like. It's difficult to chew it, so we're going to have to do it again. We're going to read it again slowly. See if we can eat it and figure it out. So this is from that court case in 1839. When the suit is against the maker of a promissory note. So let's say I wrote a check or I'm writing a promissory note. When the suit is against me, payable at a specified time, let's say the court says, you have a ticket and you need to pay this by November, or else we're going to come and get a warrant and blah, blah, blah. So payable at a specified time and place, send it to this court traffic service place here. So it says when the suit is against the maker of a promissory note, promise to pay, payable at November, whatever, to this court. No demand is necessary to be averred. Averred. Not like an avertment. What? Got it here, hanging here. Upon the principle that the money to be paid is a debt from the defendant that is due generally and universally and will continue due, though there be a neglect on the part of the creditor to attend at the time and place to receive or demand it. It's confusing because when they use the word creditor, you're thinking it's the court being the creditor. Oh, what does that mean? To attend at the time and place to receive or demand it. I don't know. Get lost with that stuff. I guess you need to know about the word averred, huh? Is that like a negative averment? Aver, when they're going to take it? No demand is necessary to be averred upon the principle that the money to be paid is a debt from the defendant, the one who got a ticket, a traffic ticket or something, that is due generally and universally and will continue due. You gotta continue to open case here because you gotta do your promissory note. Though there be a neglect on the part of the creditor. Are you saying that you're the creditor, judge, or court, or whatever you are? What are you guys? You guys aren't judges. You're administrative tribunals. Oh, traffic services. To attend at the time and place to receive or demand it. 12. Oh man, they don't explain anything. 38 US. Gotta look that up. 38 US. 13 PET. I don't know what that means. 136, 149. From 1839, see Stephan, Supernote 9 at 65 through 68. Okay, I don't know where that is and how to find it, but I don't want to lose my spot. But those are some things to look at because I didn't quite understand that Supreme Court. Let me just look at what it says. In 1839 case Wallace versus McConnell, the United States Supreme Court refused to require presentment for payment of domiciled paper. So they refused to require presentment for payment. Don't really know what that means. I guess it's these people, you know, the creditor people, like let's say the judge people or what the courts. They're the ones that when they neglect on their part of the creditor to attend at the time and place to receive or demand. Okay, so this thing, right, it says Supreme Court refused to require presentment for payment of domiciled paper. Does that mean that they just said, you owe us some money? Yeah, how so? I'm wondering if they're like saying right here, the Supreme Court refused to require presentment. I don't know what that means. Refused to require presentment for payment of domiciled paper. So I don't exactly know what that means, but I'm thinking that it means they can still keep that case open and still ask me to pay them. They don't really need a presentment for payment of domicile paper. You can still keep it open and still be charging me whatever. And then that's how they can put your, what do they do? I don't know. Find out. What do they do with some of my friends? They did a warrant. They go, pay us. But I already did. Anyways, let me move on. I digress. Okay, so the result was that makers, that would be me, the maker, had no presentment rights in the United States, regardless of the type of promissory note. The resulting disadvantage for the maker is that if the holder, that other one, delays collection of the note after it's due, interest continues to accrue on the note. Yeah, in the sample notes at the rate of 10% compounded annually. That's why they can do all these other civil charges. Yeah, that's why they can keep doing that. That would be the OID stuff, right? If the holder, that would be them, delays presentment for a substantial period of time, and if the note is for a substantial principal sum at a high rate of interest, the hardship placed on the maker, that would be me, may be very great. The maker's difficulties are further exacerbated when the original payee on the note is no longer the holder. Oh, that's because you're going to sell it. You're going to put it to collections. Boom. If the note is negotiable, B, may have sold, or C, they sold it already. That's what they do. They sell it, and then some collection agency comes. Or given the note to C, that would be the collection, in satisfaction of a debt. B, that would be the courts, by endorsing the note over to C, relinquishes his right to payment of A's debt. It is now up to C to collect on A's obligation. Oh, I get this now. I went to collections, especially with notes payable only after a period of years. The note may have changed hands many times, and they keep, those lawyers and all those people, they just keep selling those collection agencies when they call you up on the phone. Pay us. You better pay us. This is the county collector or whoever they are. This is traffic services. You need to pay your thing. And then you just be like, UCC 15? I don't know. Title 15? Is that what it is? Yeah, Title 15. Don't be calling me on the phone. I don't have any dealings with you. Show me the contract. I don't have a contract with you. Quit harassing me. And then you can send them a letter, I guess, and say Title 15. Anyways, thus, the maker, that would be me, the maker, may not even know the identity of the holder. Who are you, who are you, bill collector person? Although domiciling the note assures the maker that the holder, whoever he may be, must collect. Excuse me. Must collect at a place known to the maker. Oh, that's probably why they have the collection services in the same place, like the courthouse or whatever. They'd be like, no, we're not a third party. We're the court. We're the law. We're asking you to pay us. That's what they're doing. They're hiding in another department. The same building. That's what they're doing. That's what they're doing right here. Boom. Right here. Thus, the maker, that would be me, may not even know. Who are you? You're traffic services? What? Your collection for the courthouse? Nah, it's a third party. Where are you located? In the courthouse. Oh, in a different room? Mm-hmm. Okay, I gotcha. So you don't even know who those people are because they went and sold out. You know, it went to collections. Someone else has bought it. It's paid for. Hello. Although domiciling the note, you know, a pay to the order of the courthouse, whatever, assures the maker, that would be me, that the holder, the courthouse, whoever he may be, must collect at a place known to the maker. That's why they have their what's it called? Other offices. There are different departments in the same building. That's how they're doing. Go back. How did you do that? Shoot. Where am I? Oh, here. The hardships placed on the makers of negotiable instruments spurred creation of a mechanism by which makers, could stop the accrual of interest on the note caused by the holder's delay in presentment. The law of tender was the answer. Oh, okay. So is that why we agree to all charges? Yeah. And we go ahead and tender the payment, and we say pay to the order of the United States Treasury, and the same to the all caps name, and send them a money order. Okay, that's cool. The law of tender was the answer. Our style money orders right there. Boom. B, formal requirements of a tender of payment at common law. A tender of payment is essentially an offer by the maker, that would be me, the maker of the note, to pay his obligation to the holder when it becomes due. Due by November. All right, paid to the order, like an A for V. Yet a tender of payment is really more than an offer. A tender, while having many of the characteristics of an offer, is in the contemplation of the law more than an offer to perform the obligation required of the obligor under the terms of his contract. In other words, tender is a broader concept than offer. The former including the latter. Okay, so the tender is a broader concept than offer. The former is the tender, the latter is the offer. Every tender includes an offer, but every offer is not a tender. Okay, this is reminding me of Alice in Wonderland. I was reading the, what's it called? Cracking the Code. And in Alice in Wonderland, the hare, Mad Hatter or the hare, whatever, was saying, this does not mean that. Every tender includes an offer, but every offer is not a tender. So let me see. So when we tender, we say pay to the order of the United States and charge the same to the all caps name. Here's $1,000 or whatever it is, $900, whatever for this ticket, blah, blah, blah. And you're making that, what do they call that? Presentment, negotiable instrument of the money order. And that right there is a tender, which has an offer. But like, let's say that you just said, oh, I promise to pay you on the phone. That's an offer, but that's not a tender. Like that's not writing a money order. Okay, that's what that means. So 14, let's see, go down here, comment, super note 5 at 326. All right. Here's this 38 US. Maybe we'll have to look up that 38 US, or we could look up the UCC 3-104 for these comments. All right, so now, what then makes a tender of payment more than an offer to pay the sum due on the note? Oh, the common law worked out various requirements that must accompany the offer before it becomes a bona fide tender. Number one, the elements of the offer. At common law, an offer could be a tender only if it was unconditional. Oh, okay, at common law, an offer could be a tender only if it was unconditional and manifested the readiness, willingness, and ability. Do you have the ability to pay? Ability of the maker to pay the holder the sum due on the instrument. So you say something like, I accept all charges. Can you pay this today? They'll say. All right, 15, what does it say down here? Bank of Lafayette versus Giles, 208 Georgia, 674, 680. Go back. Rotman versus Heavener, 54, Cal App 474, 202, page 329 from 1921. A tender of payment. How do I get it to go to the next page? What page am I on? Don't know. This must be the next page. Wait, go back a second. A tender of payment, in other words, had to be more than a hollow offer by the maker to extinguish his obligation. Okay, you know what that means, right? Hollow offer. Like, yeah, I'll pay you. The check's in the mail. And you never do it. That's a hollow offer. Check's in the mail. When it's not, that's a hollow offer. You're placating them. You're telling them what you think that they want to hear, but you actually have to, do something. So the unconditional nature, unconditionally, that means there's no conditions on it. You got to do it. Unconditional nature of the tender right here, it could be destroyed by tendering the sum subject to a counterclaim against the holder. I guess that would be, I'm thinking of some friends of mine. They'll be like, oh yeah, we'll pay you. And then like, I'm going to sue you. Do a counterclaim against the holder. All right. A maker could insist, that would be me, however, that the holder, the courts, or whoever, perform a statutorily imposed duty without destroying the unconditional nature of the tender. I don't know what that means. A maker, that would be me if I'm making the check or money order. I could insist, however, that the holder, the courts, perform a state statutorily imposed duty without destroying the unconditional nature of the tender. Where it is the duty of the creditor on tender of payment, because I could have sworn we were the creditors. We are the creditors. I'm just saying, on tender of payment, to do a particular act. Are they saying that those people are the creditors? That's what I'm thinking. The offer to pay may be coupled with a demand. The offer to pay may be coupled with a demand upon the creditor to perform such act. In the example, in a case where by statute it is the duty of the creditor to give a release. On tender of payment, a release may be demanded. Oh, so we need to demand a release? Okay, on tender of payment, a release may be demanded, for it is the performance of a duty imposed by law. Let's go down to 17. Baum versus Wambog, 16, Minnesota, 106, 108, 1870. Upon payment, the maker, that would be me, today has a right under UCC. I have a right under UCC 3-505 1A to return of the note to a return to a return of the note or receipt of payment. A return of the note or receipt of payment. That's why you say, oh, Can I have a receipt of the payment, please? Oh, so that's how some of those mores and the different ones, they go ahead and they pay it. Then they say, can I have a receipt of the payment so that they can do the taxes maybe and get their money back that way? Is that how they're doing it? That's what I'm thinking on 17 down there, but we'll find out. The unconditional offer by the maker, that would be me, had to be for the sum owing at the time of the tender. So like, if they say your bill is up to $800, and if you go past November, it's going to be 1,000. So you write a accepted for value or a money order for $800 and you send it to them. I think that it's not going to be $1,000, right? After November something or whatever. That's what I'm guessing right now. I'm guessing because I don't know. Okay, older courts insisted that tenders are always to be considered stricti juris. If a tender is not legal in every respect, even a court of equity will not support it, nor supply a defect. 19, King versus Finch, 60, Indiana, 420. That's their reference down there. Thus, if the maker, that would be me, failed to tender the exact sum due of $800, then the tender was defective. Modern courts, however, have relaxed this requirement somewhat to approve a tender of a reasonably approximate sum to the holder. Can you afford to pay this much? You could say, no. How much can you afford to pay? $10? $10? No, that's not reasonable. How about $799? How about $750? Okay. It was clear, it's haggling. It was clear at common law that the maker, that would be me, had to tender payment to the party to whom the sum was owing. My beef is that, like, they don't have any laws that say I can't have a private plate. And they're assuming that me, living woman, is an entity that has a driver's license. So they're trying to charge me all this stuff. Well, I'm not going to give them Federal Reserve notes. I'm not going to send them a check out of my bank. So I'm going to give them a R-style money order, and they could take it out of the Social Security number that they own because it's theirs. And they're supposed to be doing their own discharging of the debts of their U.S. persons, whatever. If the original holder of the note, like the courts, had sold it to, like, those other lawyers who, debt collectors, or transferred it to another person, and the maker, me, knew that the original holder no longer had any interest in the note, the tender had to be had to be to the new holder. Stop. Read that again. If the original holder, that would be the courts or whoever, traffic services, of the note had sold it, went to collections, or transferred to another person, because those lawyers, they like to buy this stuff, and the maker, me, knew that the original holder, the traffic collection or traffic whatever court something, no longer had any interest in the note because they already sold it to the other person, the tender had to be to the new holder. 21. Kentucky, Virginia Stone, Fortner 159, Virginia 234, 165, SE 401, 1932. In the absence of a right to prepayment, the maker, me, could not tender payment before the note became due. And if the tender occurred after the maturity date, the tender had to include interest on the note up to the date of tender. I think that's probably why they say, look, here's your traffic ticket is $400, but if you don't show up, add 200 civil something. And now we're going to say by November, if you don't pay this by November 4th, it's going to go to 800. Then after that, it's going to go to 1,000. So I think that's when they're including the interest with these penalties and fees and stuff like that. That's what I think they're doing. That's just my opinion, though. 2, methods of tendering payment. So here's methods. You want to keep listening or should I end this? I'll see if I can read a little bit more and then we'll finish. Makers of non-domiciled notes faced considerable difficulties. Makers, that would be me, of non-domiciled notes, like if you to the court or whatever, to the United States, whatever, notes faced considerable difficulties in making a tender if the holder could not be easily located. Yeah, that's why I think you have to, when you're like discharging debt or whatever they call it, making tender, doing a money order, you kind of have to like put it to a name. The court clerk or the CFO of Verizon, because those people, they're so tricky. They're like, we didn't get it. Yeah, you did. I got the green card that has your signature on it. You got it. We don't know where it is. Yeah, that's why you gotta know who you're giving it to. You can't just send it in to put it to a person's name or something. I think that's why they're doing that. The Supreme Court of Texas in Baucom versus Great American Insurance Company of New York stated at common law where no place of payment is specified. Room 302, or fixed by law, the rule, here's the rule, that the tender must seek the tenderee. Got to get to the right place, to the right office, to the right person, and make a tender to him if he can be found by the exercise of due diligence. That's why a lot of those things you just do to the CFO, Chief Financial Officer. That's just my opinion. The question then became one of assessing the due diligence of the maker. Yeah, so that would be, I have to know who I'm making the payment to and what department it's going to, what PO box or whatever. One case did conclude, however, if the holder, that would be them, had left the state, there was no duty on the part of the maker, me, to follow the holder into another jurisdiction in order to tender payment. The ease of making a tender of payment was increased with respect to domiciled instruments through the doctrine of constructive tender. The maker, me, could effect a constructive tender by having an adequate sum on hand at the place of payment specified in the instrument. I think this is why they say pay to the order of the United States and charge the same to your all capitalized name. That's what I'm thinking. You got to be specific on that. That's what I'm reading, that I'm thinking and interpreting what this is saying. The United States Supreme Court in Wallace versus McConnell officially approved the doctrine of constructive tender when it wrote, should the maker, me, not find his note or bill at the bank, oh, he can deposit his money to meet the note when presented. Oh, the Treasury, right? Pay to the order of the U.S. Treasury and charge the same. Oh. He can deposit his money to meet the note when presented. And should he be afterwards prosecuted, he would be exonerated from all costs and damages upon proving such tender and deposit. Interesting. 26. Yeah, you can read that stuff down there. It's just a bunch of numbers that not really giving any. And okay, when I get to 28, I'll read 28. The doctrine of constructive tender evolved as a way of relieving the maker, me, from continual presence at the place designated in the note. So having to go to court all the time? Is that what that means? At relieving me from having to keep going to court at the place designated in the note? Or would it be having to go to the U.S. Treasury? I don't know. It was clear, however, that regardless of whether the note was domiciled, oh, okay. That's why you have to domicile the note. The maker, me, did not have to tender when it was certain that the holder would reject it. What? The maker did not have to tender when it was certain that the holder would reject it. Yeah, because they're like rejecting these money orders. This rule was based on the equitable principle that the law will not require the doing of a useless thing. That's what I'm saying. I'm just like, don't call me, get out of my face. You're not even going to accept this anyways. That's what I'm saying. I'm just saying. So the state of Iowa has enacted legislation to aid makers, me, of non-domiciled, we didn't put to who it goes to, the place, paper, in tendering payment to an unknown or absent holder. The statute, now here it is, 28, we're going to go down there, Iowa code. When an instrument for the payment of money is due and the holder is absent from the state, or his identity or whereabouts are unknown, and the instrument does not provide for a place of payment, the maker, me, may tender payment at the last known residence or place of business of the last known holder. And if there be no person there authorized to receive payment, like the CFO, and give proper credit therefor, ledger, zero the books, come on, the maker, that would be me, shall be deemed to have tendered payment. I did. And interest shall cease on the date of deposit if, number one, the maker, me, if I deposit the amount due with the clerk. What is this down here? This is interesting. The maker deposits the amount due with the clerk of the district court in the county. What is this new thing that I'm just learning right here? I'm supposed to deposit the amount due with the clerk of the district court in the county where the maker, me, resided at the time of the making of the instrument. If he was then a resident of the state of Iowa, or if the maker was a non-resident of the state of Iowa at the time of the making, with the clerk of the district court. Okay, I consider myself a non-resident. And number two, B, the maker within 3 days gives notice of such deposit by ordinary mail to the holder if his identity and address are known. Let me read that 2 again. B, the maker, right here, me, within 3 days gives notice of such deposit. Deposit by ordinary mail to the holder if his identity and address are known. All right. I sent to Verizon, to the CFO, a money order to pay for the whole year of the phone bill, the cell phone. Now, I knew his name and his address. I gave it to him. But then they sent me back something from the executive offices saying, we don't have a fiduciary duty for that. Letters around here somewhere. I'm too tired. I think I'm gonna have to stop reading because I'm getting tired. It is probably like 2 a.m. now. Why am I doing this to myself? Anyways, let's continue reading. The statute allows the maker. I'm going to finish this page right here, which I don't know what page it is. Oh, it says it up there, 600 and something. By the statute allows the maker to leave funds on deposit with a court for the holder. Wow, that's interesting. By tendering the debt into the court and giving notice, the maker can effect a valid tender when the holder is absent or unknown. This statute is unique in extending the possibility of a constructive tender to makers of non-domiciled instruments. Given the potential hardship to makers, me, of non-domiciled paper, when the holders are absent, this statute makes practical sense. And I'm going to finish right there. I think that this is page something, what, I can't see it, 839. I'll try to read this again soon. Anyways, stop share. I'm getting tired. Okay, 3 a.m. My God, I have to stop this. This is terrible. I need my beauty sleep. Good night.